items with particular reference to page 48, paragraph 105 of your witness statement.
Yes.
Could you please proceed dealing with those issues?
Chair, this section of my evidence deals with an award of the IT data services tender initially to T-Systems, which was then subsequently withdrawn and awarded now to Gijima. I will take you through what I say in paragraphs 105 and following, Chair.
It's page 48, Chair.
48.
48.
Thank you. Yes.
Chair, so I point out in my statement that during January of 2010, Transnet entered into the initial agreement with T-Systems for the provision of IT data services. It's a critical service for Transnet's operations. Effectively, it enables access to all critical IT data pertaining to the rail operations, ports, pipelines, personnel, a range of functions that Transnet requires in order to operate effectively and efficiently. I then say that after that initial tender was, the contract was entered into, a series of variations or extensions in value to that contract then occurred. And I explained those variations in one of the annexures which I would like to take you to. It isn't directly germane to the issue of the award to Gijima, which subsequently followed, but I thought just for context, I'd like to give the Commission a full sense of the history of the matter.
And how many variations are you referring to?
There were in total 5 variations.
And those were between 2010 and 2019?
That is correct.
And for that period, no services went out on tender?
Sorry?
During that period, no services went out on tender. It was all extended on variations.
It was extended on variations, but parallel to that, the new tender process was being evaluated and awarded and so on.
Yes. Then, may I refer you then to...
I'm sorry, extended on variations means what? Extended on variations, what does that mean?
No, I use the term somewhat interchangeably to extend the contract.
Oh, that it was extended.
Or varied in the sense of the time and the value.
But basically you mean it was extended.
Exactly.
Yeah, okay, all right.
Mr. Volmink, may I then refer you to Exhibit BP 2.1C? Chair, that should be the third file with particular reference to page 1086.
Is the reference to that file a reference to Exhibit BP 2.1C?
Yes.
Okay.
So that it becomes easier, Chair, to locate it.
And what is the page?
The page number is page 1086.
1086.
Yes, Chair.
Thank you.
Mr. Volmink, are you there?
I am there, Chair.
Yes. Could you please identify that document for us?
Chair, this document is a document which was initially prepared by our group strategic sourcing function, one of the units within the procurement department. It was a report which was delivered to SCOPA. The initial intended date of the presentation was for December 2017. That engagement finally happened in January of 2018, and the document has just been updated to reflect events that have occurred subsequent to January 2018.
And can you then take us, please, through those several variations and extensions that you alluded to?
Chair, what the document then reflects is that the initial award to T-Systems was a 5-year contract with an option to extend for a further 2 years. So the option was incorporated into the initial contract, which was to run from 1 January 2010 to 31 December 2014 with a total initial contract value of about 1.9 billion.
That was the initial amount.
That's correct.
And subsequently, you can take us through the variations then.
The variations then were as follows, Chair. Firstly, the first variation related to the exercising of that 2-year option.
Let me just take you back to this issue of variation and extension. Technically, variation might be correct when you mean extending. But normally, or rather, I associate variation with an amendment of the contents of the agreement. Okay. So I just want to confirm that wherever in this document there's a reference to variation, should I read it as extension? Or sometimes variation is used to mean something other than extension?
No, Chair, it would be the former meaning, that
Yes.
wherever we refer to variation,
Yes.
it is an extension in both time and value. So it's not just a time extension.
Oh, okay.
With the time extension, there will be a value increase as well.
So variation might be more accurate in that context. That's not just an extension of time.
Yes, Chair. Yeah,
It's also a variation of the price.
correct.
Effectively an amendment of the price that must of necessity come with the extension of time.
Precisely.
Yes. Okay, all right.
Would that
Okay.
also include the variation of the scope of what was intended to be performed?
Sometimes that may well be.
It will be
Yes.
extended.
Yeah. Yes.
Yeah.
I was then referring to the first variation, Chair, which involved really the exercise of that 2-year option that I had referred to earlier, which then extended the contract from 1 January 2015 to 31 December 2016. There were various reasons given for the exercising of this of the option. Some of them I'll mention briefly. In essence, Chair, it was said that the Transnet had contracted Gartner to review all the current services that were being received from T-Systems, to develop a new strategy, to issue a new set of specifications. The RFP had to be written, and the motivation that was given was that that 2-year extension was required in order to complete that part of the work.
And the second extension?
The second extension was for a further period of 9 months from 1 January 2017 to 30 September 2017. I refer, that is on page 1087, just the following page. And what it says, Chair, is that the 9-month extension was requested to enable Transnet to finalize the new IT data services procurement event, which was now already at the adjudication stage. So it had progressed, but it hadn't yet been completed. And a further extension of both time and value was then requested.
And the initial amount value, which was 1.9 billion, it now became 3.8 billion. Am I correct?
Correct, Chair. With all the extensions, there was a significant value extension as well, which now stood at 3.8 billion.
And that?
The third
That's
extension.
3.8 billion, eh?
Yes.
That's correct.
Yeah.
Chair, the third extension
Page 1088, Chair.
is on page 1088.
Thank you.
And what it related to was an initial request, actually for 12 months, to enable Transnet to essentially extricate itself from the unlawful award that had been made to T-Systems and to award the tender to Gijima as was initially submitted by management. But there was a process of litigation that had unfolded. And the concern was that the litigation process would not run its course within a 12-month period. Eventually, National Treasury approved the extension, but not for 12 months. They only granted an 8-month extension, during which time I think there was a considerable attempt, as I say, for Transnet to extricate itself from this initial tender award, which I will deal with in more detail in a short while. I'm just giving an overview of the various reasons for the extension.
And the fourth one, page 1089, that's where you find the fourth one.
Correct, Chair. The fourth one, the motivation that is stated in the document is that Transnet had requested this extension for the commencement of what are referred to as disengagement processes from T-Systems. It's not the kind of contract where when the contract ends, the service provider moves off and the new service provider comes in immediately. There is a process of disengagement. In fact, if my recollection is correct, the contract made provision for a 6-month process of transition and disengagement. And Treasury only approved a 3-month extension, which was then the fourth variation. And then the fifth variation
on page 1090
is on 1090. This was for the period 9 September 2018 to 8 March 2019, and there's been no further extensions after that date. So that was the last extension.
And the entire amount pursuant to those extensions or variations was an amount of 4.9 billion.
That's correct, Chair.
So this contract started in 2010
Yes.
and is still ongoing or has just ended?
Currently, it's no longer ongoing. The
Yeah.
last extension was, it expired on 8 March 2019. That's when this contract ended.
So it went on for ultimately about what, nine years?
Yeah.
Yeah. Originally it was meant to be 5 years,
5
but there was a provision for a possible extension.
Correct.
Yeah. Okay.
That's the point, Chair. May I then refer you back to your witness statement, paragraph 106 on page 48, and we can continue with your evidence from there, having now painted the context to the Chair.
From 106, the point we simply make is that governance was involved in reviewing certain of these addenda and was also then quite involved in advising the board to reverse its decision to award to T-Systems and to award to Gijima.
Yes, you may then proceed to deal with the events relevant to Gijima.
Yes, so now if I can focus more directly on the award to T-Systems, Chair. In paragraph 107 and following, I state that during November 2015, Transnet issued this RFP to the open market for the supply of IT data services. And T-Systems responded, and Kajima responded, and a few others responded. After quite a drawn-out, protracted tender process, a recommendation was made by management to award the tender to Kajima. Having said that, I should also point out to you, Chair, that my understanding is management did have some misgivings during the evaluation process about Kajima. There were various commercial and also technical concerns that management had raised, and they were not at first in favor of the award to Kajima. But after extensive engagements with Kajima, management came to the conclusion ultimately that those risks had been adequately mitigated. Based on the view that the risks had been mitigated, they made the recommendation to award to Kajima. What I then go on to say is that during February 2017, the board took a decision not to award to Kajima based on those risks that management had earlier dealt with, and to award it to T-Systems.
So this is one of those contracts which were dealt with during the period when the board was getting involved in the award of certain tenders.
That is correct, Chair. They had delegation of authority in terms of the delegation of authority framework to make those decisions.
Yes, okay.
And will this be an instance whereby the risk factors are only raised at the later stage when they were in fact dealt with by the management adequately, but they are raised in order to not grant the award to the private bidder?
That is precisely the difficulty that governance had with this entire transaction. The risks had been highlighted at an earlier stage, and as I testified, in the view of the technical and other experts who assessed the matter, they were satisfied that the risks had been properly dealt with. What then happened is...
Well, let's talk about that a little bit before you move on, and it takes us to something that we discussed a little bit yesterday, namely that if management has a right to take a view on a tender on various factors, but their role is to make a recommendation, and the body that makes the final decision is higher up. Generally speaking, the higher body would be entitled to take a view different to that of management on any of the factors, isn't it? Generally speaking.
Generally speaking.
Yes. Therefore, when a higher body takes a view different to that of management on any particular issue or factor, that on its own ought not to raise eyebrows, but it just depends on everything else, on all the circumstances of that particular tender, whether it should raise eyebrows. But one of the factors that may legitimately be taken into account in saying, should this raise eyebrows or not, is the expertise that management may have on a particular issue, knowledge, expertise, and experience, vis-a-vis knowledge, expertise, and experience maybe of the body that decides. If the subject is about some scientific, technical thing, and management consists of a committee of scientists, and I'm sitting on a higher body and I'm a lawyer, I'm going to be very careful to go against the view of scientists in a field where they are the experts.
Yes.
But it doesn't necessarily mean that I'm going to rubber stamp their view.
Yes.
I may still question, and sometimes I might show them that maybe they didn't attach proper weight to a particular factor, or they might even change their view. But what I shouldn't do is basically disregard what they are, the views they have expressed.
Precisely.
So I'm just going back to this point which we did discuss yesterday, simply because you just mentioned that you had a certain difficulty with the fact that the board looked at an issue that you had looked at as management. And my question goes back is, of course they're entitled to look at the same issue that you have looked at, and they're entitled to take a different view. The question is whether their view weighed against your view is such that it should point to something.
Yeah.
You would go along with that?
Chair, I'm in large measure, in fact, I'm in total agreement with what you say.
Yes.
Because my evidence should not be understood to mean that I'm of the view that the board is bound by recommendations of management. I mean, it's a board it's called the accounting authority for a good reason. That is the body that must ultimately make its decisions. My difficulty doesn't lie with the principle of the board arriving at a different conclusion. But, Chair, my concern firstly is that when these risks were properly evaluated at an earlier stage, at the functionality and the commercial gate, and the bidder passed that threshold for functionality, then, in fact, our own procurement rules in Transnet warns against this concept of double dipping, where someone was properly and fully assessed at an earlier stage, and then under the guise of a risk evaluation, those very issues are now revisited. And so I think that is the first concern. And the second is just the rationality of it. Because if management, and I'm not saying management is always right on it, but in this particular case, there was quite a comprehensive motivation put forward to the
which
board,
dealt with these issues.
Dealt with all of the issues, and one doesn't see a detailed, logical analysis on the part of the board as to why it held a different view.
No, I think that last part which you say is an important factor, because if the one view is fully motivated and the opposing view is not motivated at all, or motivated very insignificantly, it is something to look at. But yes, but I think I understand your position. You say it's not the principle that you have a problem with, it's the facts of the case.
Precisely.
And the fact that at Transnet there was, as I understand you, a rule or policy against what you call double dipping. Okay, thank you.
Following from the chair questions of clarification, you are also giving this evidence against the background of a number of transactions that suffered the same fate premised on these risk factors, whereby a preferred bidder who was being thoroughly assessed just simply being ignored and another entity being awarded the tender. Am I correct? That is why you are raising this issue specifically.
That is correct, Chair. This is hardly an isolated incident.
Okay.
We have seen other cases in the past where
Yes.
risks are invoked at the 11th hour as a reason to overlook bidder A in order to go to bidder B.
Yeah.
The PPM does say that risk can be taken into consideration. It says it must be a material risk such that it would cause severe prejudice to Transnet if it weren't properly taken into account, and must not involve a reconsideration of the very factors that were earlier evaluated. So the principle I have no difficulty with, but it is the opportunistic use of risk in order to not award to bidder X and to award to what appears to be the preferred bidder.
Yeah.
Let's proceed to deal with specific facts in order to at least, place the matter in its proper context. You may then proceed to tell us what happened.
Yes, thank you, Chair. So what then happened is that Kijima lodged a complaint to the Transnet procurement.
Okay, just to complete, management recommended that Kijima be awarded the contract after the concerns or reservations that management had been mitigated through engagement with Kijima.
Correct.
But the board didn't go along with the recommendation of management and decided that the contract should be awarded to T-Systems, and largely, if not exclusively, their reasons were based on certain risks that they articulated. Is that right?
That's correct, Chair.
And then Kijima lodged a complaint.
A complaint.
Okay, all right. Thank you.
The complaint was then received by the procurement office of the procurement ombudsman. It's one of the functions which I have to oversee within the organization. But because it implicated the accounting authority, there is a National Treasury prescription that when a complaint implicates the accounting authority, it must not be investigated by the organ of state itself. It must be referred to National Treasury. And that process was followed. National Treasury considered the complaint and ultimately came to the conclusion that the proposed award or the award, in fact, that had been made to T-Systems was invalid, and that Kijima should be awarded the tender.
And did governance also agree with what National Treasury was saying?
Governance agreed with the conclusion that the tender was invalid, that the tender award to T-Systems was invalid, and that the tender had to be awarded to Kijima. So we shared that conclusion. We held slightly different views on how risks ought to be, technical differences that we had, which perhaps we don't really need to delve into.
But what is then the advice or the recommendation of governance?
Well, when governance considered the matter, we produced quite a comprehensive memorandum on the matter as well, spelling out the various risks and how it had been mitigated. And we then made the following recommendations, which are contained in paragraph 110.
Page 49, Chair. Yes, you can take us through.
And we recommended that Transnet abide. The first recommendation is Transnet must abide by the ruling taken by National Treasury. Secondly, that T-Systems should be invited to make representations on how, on Transnet's proposed decision to abide the ruling of National Treasury. We felt it would be important to invite T-Systems had now already been awarded the tender, and our proposal was, well, let us withdraw it, and we thought that a procedurally fair process would be to at least invite representations. The third aspect of our recommendation was that Transnet should proceed to make the award then to Gajima following a judicial process to set aside the award to T-Systems. We were conscious of the rule against self-help and so on, and we thought it would be better to follow a judicial process rather than simply withdrawing from one and awarding to another.
And what ultimately happened to that tender?
Chair, I should perhaps just say that the views that we had expressed were also confirmed by senior counsel. We had sought the opinions of Advocates Sabeko and Advocate Ford, and they were in large measure in agreement with the views that were expressed. Chair, ultimately what then happened is after much deliberation, the board then took a resolution to set aside its earlier award to T-Systems, and Transnet then approached the High Court for an order declaring its earlier award to T-Systems to be invalid, and a direction that it be allowed to award to Gajima. The matter was initially strongly opposed by T-Systems, but after some preliminary skirmishes, they withdrew their opposition, and the matter was then set down for hearing in the Johannesburg High Court on the 12th of December of 2018. And the court essentially granted the order as prayed for by Transnet, and I've attached a copy of the judgment in the papers.
So it was only after all those interventions that the board then decided to do the correct thing?
Correct, Chair.
Now, from page 113, paragraph 113, page 50, you are now dealing with the acquisition of the 100 locomotives.
Correct.
Can you please take us through that?
Chair, I was asked by the investigators to look at this confinement for the acquisition of 100 locomotives that was initially confined to a company called Mitsui Africa Rail Solutions, or MARS for short. And a second confinement where the initial proposed award to MARS was now completely ignored, and a second confinement was then motivated for the award of the very same tender to China South Rail, or CSR. And I was asked to reflect on just on the rationale as contained in the confinement documents itself.
Yes, and then what transpired when you have, after having reviewed and assessed, the two confinements?
Yes, so Chair, in essence, I say in paragraph 113 and following that the initial motivation was made in October 2013. I said in my initial statement that it was submitted by Mr. Brian Molefe, but upon further consideration of the documents, I see he did not sign that confinement. Hence, in my amended statement, I simply make the point that a submission was made rather than. But apart from that minor change, the point that I make is that this confinement described in glowing terms the virtues of Mitsui, the Mars, why we should award to Mitsui Africa Rail Solutions. And for example, Chair, I point out that in paragraph 114, there are a number of sub-paragraphs. It says there that these Mars locomotives, they were, I think, for the class 19E, it's a particular class of locomotives. These Mars locomotives are known, they meet requirements, and prototyping is not required. They've done this before. It goes on to say that the confinement to Mars was required for purposes of standardization, because Mars had done a number of these tenders, a number of the locomotives before, that there were Mars facilities that were readily available for immediate production. Lead times would be kept to a minimum, and also there would be significant savings. Across the page, on page 51, the virtues of Mars are further extolled by the individuals who submitted the memo. And it says there that the Mitsui models were operating optimally and, in fact, exceeded their design parameters. That we don't need to train our drivers on any new models because they've been trained on the Mitsui model. So they also speak about extensive socio-economic benefits that would be as a result of the award to Mitsui, including job retention at Transnet Engineering and job creation. And ultimately, they said it was not in the interest of Transnet to follow or to award to anyone else. So in essence, what we see is a motivation to confine to Mars based on what were depicted as outstanding qualities that Mars had.
And that was the justification why Transnet was not supposed to go out to tender on an open, fair, competitive bidding system.
That was the basis for the confinement. That's correct.
Yes. However, 3 months down the line, there was...
Then,
yes.
Correct, Chair. This Mars confinement served at the meeting of the BADC, which is a subcommittee of the board, which is entrusted specifically with procurement matters. And I wasn't at that meeting. I have no personal knowledge as to what transpired, who said what at that meeting. All we know from the record is that 3 months after this initial Mars confinement had been made, there was now a second confinement, this time to award the tender to China South Rail and no longer to Mitsui, and I've also attached a copy of that confinement to the papers.
Yes. If I may refer you to Exhibit BB 2.1D. You can now ignore C, we're now going to D.
Sorry, let me just put C away. Yes.
In the meantime, can I ask whether this second submission for confinement meant that there were going to be 2 submissions before the BADC for confinement, one to Mitsui and the other one to South China Rail, or whether the first one was effectively withdrawn?
I think it's the latter, Chair. I think the first one was effectively withdrawn because if one looks at the contents of the China South Rail confinement, there it is said that Mitsui's quality and all the various aspects that were firstly praised in the first confinement.
Yes.
They say no, Mitsui is not up to scratch.
There's a dilution of the praises that had been heaped on Mitsui.
That is correct.
Yeah, okay.
If you go to page 1196,
1196 or 1197?
1197.
Certainly.
1197. This will be
I'm sorry, I thought that was D.
D for
D for Doris.
For Doris.
Yeah, okay. D for David, D for Doris. Okay.
On page 1197, Chair.
Okay, so that's 11.
97.
Thank you.
Could you identify that document for us, Mr. Volmink?
Chair, this is a submission made by Mr. Brian Molefe, the then Group Chief Executive of Transnet, to the Transnet Board Acquisitions and Disposals Committee, the BADC, and the subject simply says mitigation of MDS volumes. MDS just stands for Market Demand Strategy. MDS volumes at risk through investment in and procurement of 100 Class 90E equivalent dual voltage electric locomotives and 60 Class 43 diesel locomotives.
And this is the one that was motivating the award in favor of Mitsui.
That is correct, Chair.
Yes. Now, while you're still opening that memorandum, may I also refer you to page 1223. And could you please identify that document for us?
This is a submission from Mr. Brian Molefe to the Transnet Board of Directors dated 21 January 2014, which has the same heading as the earlier confinement that I had quoted. It also says mitigation of MDS volumes at risk through investment in and procurement of the 100 dual voltage electric locomotives.
But this one, a different entity was motivated for.
Correct. This is now the CSR.
Now, did you have an opportunity of reading both these memorandums? Are they different in any manner?
Chair, the documents, that the two memoranda are essentially, the substance of it is almost identical. Where it differs is where the virtues of CSR are now extolled in the second memorandum, whereas the qualities of Mars are highlighted in the first document.
May I now refer you back to your statement, Exhibit BP 2.1A.
Yes.
And page 51, and take us through paragraph 116 and onwards.
Chair, in paragraph 116 and following, I simply highlight I deal with my observations of these confinements as I was requested to do by the Commission, the Commission's investigators. And what I say in paragraph 116.1 is that the confinement to China South Rail firstly invokes urgency as a ground for confinement. And as we discussed yesterday, urgency is something that has to be dealt with immediately because of a potential crisis that is looming. And I make the point that 3 months had already elapsed since this earlier confinement to Mitsui, which was also based on urgency, by the way. And no steps had been taken to procure any locomotives during that time. And I question whether this matter could genuinely be urgent if no action had been taken. But I think more significantly, the second point that I make is that this memorandum, it misquotes the PPM. And perhaps, Chair, if you will allow me, it's a very short clause from the PPM that I just want to read into the record.
Yeah, you may do that.
In paragraph 116.2, I say that the memorandum quotes the PPM as stating the following, quote, where a genuine unforeseeable urgency has arisen. Such urgency should not be attributable to a lack of proper planning, and then the underlined words are added. However, where a genuine urgency has been created by the lack of proper planning, urgency can still be relied upon as a ground for confinement. In such cases, appropriate action must be taken against the individual or individuals responsible for the bad planning. Now, I say it misquotes the PPM because those underlined words were contained in a draft which we had submitted to the board. And it relates to a point, Chair, which you made yesterday, which is to the effect that if a genuine urgency has come about, but it is as a result, even if it is as a result of poor planning,
Yes.
there is still an urgency
Yes.
to be dealt with. And it can be relied upon as a confinement, but you must deal with the individual who has created the crisis. But when this was taken to the board at the time, they felt strongly that bad planning could never be an excuse for confinement, and they deleted the reference that has been underlined here. So I think the point is that the rule which they had now relied upon is not it's a non-existent rule.
Yes, yes.
I think furthermore, Chair, I make the point in paragraph 116.4
On page 52, Chair.
Well, I'm just still thinking about this point about poor planning and agency. For what it's worth. I think you understood the point when we had a discussion yesterday. I mean, if the Commission's administrative wing was supposed to bring something to my attention to say, I must please convene a certain urgent meeting to deal with a certain situation, because if I don't convene that meeting and a certain decision is made, we won't be able to sit in this venue from next week, and the Commission will have nowhere to sit. And I think that the administrative wing should have told me a month ago. I can't say I'm not going to convene a meeting because you people had poor planning. You should have told me last month.
Yeah.
I'm going to say you should have told me last month, but now that this has happened, I must convene the meeting because we can't afford not to sit next month, next week, because we'll have no venue. So I deal with the poor planning, but I recognize that there is urgency because, for example, the lease is expiring over the weekend.
Yeah.
So the meetings that are set, the hearings that are set down for next week and the other week won't take place if I don't meet with the landlord and say the administration has really been poor in planning. They should have brought this to my attention, but now they should have brought it to my attention much earlier, but they have now brought it. Can we do something? I can't say I'm not going to meet with the landlord because They should have told me last month.
I'm very and fully appreciative of what you are saying, Chair.
Yes,
That
yes.
also motivated
Yes,
the inclusion
Yes.
of that clause, the sentence that
Yes.
was underlined.
Yes.
Management felt that if you are dealing with a genuine emergency, then we can't close our eyes to the fact that there could be an operational
yes,
implosion
yes.
as a result of not obtaining
Yes.
a particular... Let's deal with that
Yes.
perhaps on a confined
Yes,
basis.
yes, yes.
Sometimes with a heavy heart one has to
That's right, yes.
agree to these things.
Yes.
And discipline the person, but let us acquire the product. If I recall correctly, the board's concern at the time were these self-created urgencies and how easily it gets invoked as a reason not to follow a procurement process. There was a view that the system had been subject to abuse, considerable abuse.
Yes.
Maybe the pendulum swung
Yes,
quite
because
far
of that, yeah.
onto the one side.
Yes.
But I think that
Yes.
that motivated the exclusion of
Yes,
the
okay, no, that's fine.
You may proceed from paragraph 116.4.
In paragraph 116.4, I make the point that certain grounds for the confinement that are set out now in the CSR memo were identical to the Mitsui memo. It's as if the grounds for confinement, there was like a cut, copy, paste exercise done from the grounds of confinement for Mars and put into the Mitsui. Now they also say that these diesel locomotives from CSR, they are known and they meet technical requirements and setup costs are not required and facilities are readily available for CSR, the very things that were said about Mitsui. And I make the observation, Chair, in the middle of that paragraph, I say, assuming that these facts regarding CSR were true, that they had all of those qualities, why was the confinement then not made to CSR in the first instance, and why did it take 3 months to realize that CSR actually had the same attributes as Mitsui in relation to setup costs and prototyping? And at very least that suggests bad planning. And when there is bad planning, as we've said, that effectively negates the ground for confinement. And that is the observation that is
But
made.
let's deal with the effects of these numerous confinements. What they meant was that a party that was never subjected to any tender process, a name will be mentioned and an award will be given to that entity.
It's slightly more complex than that. So an entity would be recommended as for the confinement.
Yes.
It has to be approved by the person with delegated authority.
Exactly.
But it is still a tender process. So an RFP would then be issued to that one, or sometimes one or two or three, however many entities are listed in the confinement. Submissions must be received, it must be evaluated, it must serve before the Acquisition Council. I think the fundamental difference is that it isn't an open invitation to any bidder.
In this regard, there were only two memos. The first one motivated Mitsui,
Only Mitsui
and the next one motivated only.
only CSR.
Yes, that's the point that, yes.
Yes.
You may proceed then.
I also point out, Chair, that the CSR memo now refuted the very qualities that had earlier been stated about Mars. It now says that Mars had not done well during the 1064 LOCO process, and there was another 95 LOCO transaction. It also says that this SD of Mars was not supplier development was not a key factor when Mars was awarded the contract. And then it also says that if we continue with Mars, that would create unnecessary risk for Transnet. It says that CSR, on the other hand, had excelled in all of these SD requirements. And Chair, in essence, I come to the conclusion, having dealt with all of this, that the about turn in such a limited period of time, I think it defies rationality, it defies logic, at least from my observation. I should also point out, and I deal with this in paragraph 117, that it was, in addition, it was stated that regarding these reputational risks that Transnet would suffer, it was then said that it wasn't elaborated on, but except to say that there was speculation in the media around Mitsubi's local partners and their political affiliations. And it said that Transnet would never entertain awards based on the political prowess of any business partners to an OEM, but the risk does not need to be taken into account from a reputational risk. Essentially, they were saying, look, we hear some worrying stories. But the point is, why were those worrying stories not a factor when Mars was motivated for confinement 3 months earlier? I mean, these stories had come about, I think, way before that. So I think all of this, Chair, the most generous interpretation that I can give is that it is as a result of just bad planning. And I say that's the most generous. Whether there are other nefarious motives that influence this, others will come and testify.
Yes. Just lay those bases fine. Then we can proceed, Mr. Volmink, to deal with the Mackenzie confinements.
As far as the Mackenzie confinements are concerned,
They're from page 54, paragraph 118.
Chair, I say in paragraph 118.
I'm sorry, Mr. Volmink.
Yes.
When the BADC, that board committee, dealt with matters such as this, this request for confinement, would they have the benefit of somebody at that stage? I know the recommendation that you expressed going forward. Would they call for somebody with some more knowledge of procurement from within Transnet and say, there's this request, give us some advice, what's your view, is this in compliance, is this not in compliance with the prescripts and policies, or would they rely on the relevant executive members of management or CEO and so on?
Chair, if memory serves me correctly, the ADC called the Group Chief Supply Chain Officer to attend their meetings and to, I would imagine that if there were procurement process-related issues, they would look to the Group Chief Supply Chain Officer to say is this correct or not correct.
Yeah, so they would have at the meeting available to them such a person.
Correct, Chair.
Yes.
Whether that person was present when these matters were discussed, I can't say.
Yes.
But usually the Group Chief Supply Chain Officer would be present at these discussions.
Okay. Thank you.
Can we now move on to deal with the Mackenzie confinements?
Chair, with regards the McKinsey transactions, I've also been asked to comment on the grounds of the confinement to McKinsey. I make the point in paragraph 118 that over a 3-year period, 2012 to 2018, there were at least 8 contracts that were awarded to McKinsey Consulting for various consultancy work.
And these all 8 were on confinements?
All 8 followed a confined tender process. And a summary is contained in the bundle, in the annexures, but on the next page, Chair, on page 55, paragraph 1251 to 1258, I summarize these confinements.
And what is the value, the total value of these confinements?
Chair, the combined value of these various confinements came to about 1.6 billion, and with some amendments and increases to scope of work and value to about 2.1 billion.
All that did not go out on tender?
It did not go out on open tender. It was awarded by way of a confined tender process.
Yes. Now, from paragraph 120, you express certain views about the justifications that were contained in the confinement. Could you please take us through them?
Chair, I highlight various views which I have of the confinement, starting with the entrenching of monopolies.
Yes.
And I say that because in the PPM, which is our manual of how these things are to be done, it in fact cautions that because confinement is a departure from an open tender process, it must be dealt with great circumspection, quote unquote. And it warns, just lower down in that paragraph, I say that the PPM also warns that the misuse of confinement has the potential to entrench monopolies, and as such is at odds with the imperatives of the new growth path, which was one of the flagship government policies at the time. I make the point, Chair, in paragraph 122, that our procurement procedures required our delegated authorities to be vigilant against the creation of monopolies. And at face value, any company who has received work by way of a confined tender process over a 2-year period with 8 awards being made, totaling 1.6 billion, on the face of it, that seemed to create a monopolistic situation. What I also highlighted is that there was some awareness, even on the part of the Group Chief Executive, about the dangers of monopolies. So when certain of these confinements were brought forward, I deal with this in paragraph 123. There is a submission that served before the Acquisition Council at one point, and it contained the following paragraph, which you will find in italics towards the end of paragraph 123, and it says, during post-tender negotiations, the GCE raised the concern that Transnet had been awarding business excessively to McKinsey and Company. And as a result, this will expose Transnet to insurmountable risks should any unsavory circumstances occur. And at that point, a decision was made to award part of the business to Deloitte's, but even that ended up in being cancelled, and the award was made to McKinsey. So I think in essence, despite the earlier concerns and awareness that we could be dealing with a monopolistic situation, the award proceeded nevertheless on all of these tenders.
Yes, take us through the grounds of confinement as you discussed from paragraph 125. Chair,
in 125, I just again quote what our internal grounds are, and I say that these confinements relied on two grounds. Urgency, firstly. I mentioned that as ground A in paragraph 126. And ground D, which is that services are highly specialized and largely identical to work previously performed. And I just want to engage for a few moments on both of those grounds, whether they were justified in the context of the McKinsey transactions. Under urgency, Chair, it is stated that the ground for confinements are urgent based on certain revenue-related risks. It was stated that EBITDA is at risk, and there's a need to deliver on MDS, the market demand strategy, which was a flagship program of Transnet at the time. And it states that if we don't get these services, we could place the whole MDS at risk. Now, as I testified yesterday, the grounds for urgency is that it must be a genuine, unforeseeable urgency. And I say in my statement that the PPM contemplates that the situation that gave rise to the urgency should not be anticipated and should therefore be genuinely unexpected. And I question whether the revenue risks that were highlighted were genuinely unexpected. A revenue risk is not something which Transnet would realize now. One sees declines in volumes and declines in revenue usually over a period of time. And I certainly don't think that was unforeseeable. On the second ground, which relates to the fact that the services from McKinsey are highly specialized and largely identical to work which they previously did, I say the following in paragraph 130 of my statement, Chair. I say that all the confinement memos justified the confinements to McKinsey on the grounds that it would result in wasted time and money. It was stated that a new service provider would have to acquaint itself with Transnet's pricing strategies, capital program, overall MDS, whereas McKinsey already had that knowledge. And ground D does make allowance for a situation where I can confine to someone on the grounds that it's a highly specialized service and I just want a bit more from that person based on what they have done before. In Transnet, we refer to it sometimes as the school fees clause. We say we have paid the school fees of this consultant. He has come to learn all of our shortcomings, our difficulties, our systems, and we want him to do an extra bit of work. But if I have to go out on tender, I must pay the school fees now of another person who's having to relearn all of these difficulties. So in an appropriate case, I think there is justification for such awards. In fact, I think the first few McKinsey transactions, the first two or three, I supported that at the time. I thought there was a justification for it based on the school fees clause. But what we have here, Chair, is that it is now said that McKinsey has they've got a proprietary iron ore demand and supply model, and they've got proven toolkits for negotiation and the like. And
I guess that since we're talking about quite a high number of contracts that were awarded to McKinsey, I think your statement says about 8.
Correct.
I guess that you might not have just paid, the school fees. You must have taken them to university as well.
So we've
So it
taken
had to
them,
take long.
we could have paid for many universities.
Mr. Chair, on that university note, I see it's 11:15.
Yes.
Would it be time to-
Okay, we'll take the tea adjournment and resume at 11:30. We adjourn.
All right.
of your statement. Please continue and
That's
summarize what you're saying there.
Thank you, Chair. The point that I was addressing before T relates to the second ground for confinement, where it was said that the services are highly specialized and only obtainable from Kajima. What I say in paragraph 131 is where the PPM
Did you
deals...
say from Kichima?
Not Kichima.
Sorry,
We long
You
past
mentioned Kichima.
oh,
We long past Kichima.
sorry, my apologies, Chair. What I
China South and Mutsui.
yes, I think we had
That's
also
where we
passed there.
Oh, we
I
have
think
passed
are now
that as well.
With McKinsey. I think
Oh, we are at
I meant to say
McKinsey. Yeah. Okay.
The point that I wanted to make is that where this ground is dealt with in the PPM, it says that when this ground D is relied upon, proper consideration must be given to the public interest as well as Transnet's interest. In other words, it conveys the notion that it is not sufficient for Transnet officials to consider the fact that these services are highly specialized and can only be obtained from McKinsey. I make the point that there is an overwhelming public interest in open, fair, competitive tendering processes and the avoidance of monopolistic situations. And had that requirement of the public interest been taken into consideration as well when that ground D was considered, I think it would have pointed us away from repetitive confinements to McKinsey when the public interest in fact required something else. And there can, in my view, Chair, be no distinction between the public interest and Transnet's interest as a public body. Chair, I then deal with another concern which I picked up, and that is that in a number of instances, payments were made to McKinsey even before the tenders were awarded. So the tender is still underway and payments have been made. And I deal with that in paragraph 132.
Yes.
And following.
May I then take you to Exhibit BB 2.1D for David?
Yes.
And if you may please go to page 1342.
Yes.
In order to substantiate what you are saying in paragraph 132, you then place reliance on a number of emails starting from page 1342 onwards. Can you please take us through the emails?
Gladly, Chair.
You can follow the chronology that suits, the version.
Chair, perhaps just for purposes of chronology, it may be better to start with the first email which you find further down in the
I'm sorry.
annexure.
I'm on BB 2.1.2.1D. Is that a wrong lever?
That's the right one.
That's the right one?
Yes, on page
Page
1342. 1342.
I think I was on 1242. Yes.
Chair, if we can start on page 1344.
Yes.
It is an email written by the then procurement manager, Cindy Felix, to Mr. Edward Thomas.
The one at the bottom.
That's correct, Chair.
Yeah.
Right at the bottom. And it is dated the 11th of July 2014. And it says, Dear Edward, I refer to your text message received this morning where you have instructed us to create purchase orders for payments to be made to McKinsey where no contracts exist. As the P2P, that's procure to pay, business process owner for TCC, she's not describing herself, please be advised that I require written permission via email from you as the acting group chief supply chain officer to request my team to create purchase orders, as this is a deviation in the P2P process and effectively our supply chain policy and procurement procedures, which is based on the regulatory statutes we are bound by as a state-owned company. It is my understanding that the payment request is from business and is being approved as duly payable by the Group Chief Financial Officer Anuj Singh as the respective delegated authority for Transnet and custodian of these transactions. She continues, we assume that the applicable risks in making such payments have been considered before release of these respective requisitions. And she then lists these various transactions where payment is supposed to be made. She says the tenders according to you affected include the following. She refers to the coal breakthrough of 2 metric tons. That is one of the confinements to McKinsey. And she says, she's now giving a status update. She says, no evaluation is in progress. Business is not responding, and the business owners noted that the business does not agree to this request. In essence, she's saying there's no evaluation has happened yet, but we must pay the service provider. She mentions the next one relating to the renegotiation of the Kumba iron ore contract, also one of the confinements. She again says no evaluation in progress, business not responding, and business owner wanted. I think it's pretty much the same status. Regarding the third confinement, regarding the manganese execution initiative, she again says it's currently in evaluation stage. The fourth confinement, NMPP de-risking and acceleration, currently in evaluation stage. And capital optimization, which is the fifth one, she says it's only issued on 10 July. And we only received supply chain management sign-off this week. And she concludes by saying, kindly be advised that we do not, and she underlines, do not recommend that this be paid, and she puts it in bold. Until such time as these contracts are concluded, as the scale of the risk is significant in relation to the payments being made to service providers who knowingly took on the risk of doing work without a proper tender process being completed. There are other paragraphs which follow, but I think that,
that captures the essence
of what she was saying, which in my view captures the internal controls absolutely correctly.
And then what happened after she have now dispatched that email?
Well, then, Chair, we have another email from Mr. Edward Thomas now in response to the email from Cindy Felix. And the contents you will find on page 1344. And he says, Dear Cindy, firstly, a contractual obligation has been created once the confinement process was approved. A letter was issued to McKinsey whereby Transnet requested them to commence work while the RFP was issued, and they were to respond to the RFP indicating that should Transnet not conclude the procurement event after the RFP was completed, Transnet commits to pay for work delivered until that point. Thus, a contract is in place. Thus, no condonation is required at all for any payment that is to be made. Thus, there are no risks regarding this payment that can be validly made. The fact that Transnet will be negotiating price further through the RFP process will be taken into account in future payments to be made. And in essence, he is saying that as far as he is concerned, a contract exists and payments can be made against that contract.
Despite that thorough analysis that really showed that the process was incoherent at that stage, and there was no contracts in place at that stage.
That is correct, Chair. With respect, I think that the contents of this second email, the contents are patently incorrect. A confinement, when one gets approval to confine, it
Doesn't create a contract.
It does not create a contract at
And
all.
everybody should know that.
I would imagine. And all it does is to say you have permission not to issue this RFP
For open tender.
for open tender, but you can now issue the RFP to this one or two or three or however many you have confined to. And then what follows is a process which mirrors the open tender process.
Yeah, but confined
to those two or one or however many. And the contract gets concluded at the end of that process. It is unheard of that one can conclude a contract first and then evaluate later.
The supplier later.
I've never heard of
I
such.
mean, what point would it serve to evaluate whether the supplier is the right kind of supplier if you have already concluded a contract?
Oh, precisely, Chair, because even if it is a confined tender, it must go through a rigorous evaluation process. If that bidder doesn't make any of the thresholds, let's say for functionality or local content, that bidder is excluded, the bidder falls away. But if I already have a contract in place, I've really put the cart before the horse, and I think that is exactly what happened in this instance.
Any email that you want to complete with?
I think there is then just a follow-up email where the staff is told that, look, Eddie has now informed us that there is no breach or deviation and payment must now be made. I think that the staff felt that they now had no alternative.
Yeah, they had made their points.
They've made their point, they've stated their position, but someone higher up in the food chain had instructed that the payment must be made, and I think the impression that one gets is under protest, the payments then flow.
Can you take us from page 60, paragraph 133 onwards?
That is back to the statement?
Yes, back to the statement, Mr. Chair.
Yes. Chair, I then just, I make the point there that there should have been no confusion about this to begin with. Because in our procurement rules in the PPM of the 2013 version which applied at the time, there was a provision which I quote in paragraph 134, where it says, no employee shall anticipate the approval of acceptance of bids. Therefore, no employee may enter into contracts verbally or in writing or place any orders before the prescribed adjudication process has been performed and authority has been duly granted by a manager with appropriate DOA. So that rule was always there, and there's a further provision that says even if you have a confined tender, it says those tenders will, quote, close at the relevant acquisition council. What that simply means, as I've explained before, is a tender gets issued, there must still be a closing date, and all the normal processes of adjudication then follows. And that is what I deal with on in paragraph 134.
Yes. And 135?
In paragraph 135, I say that on the 9th of April 2014, well before these RFPs were issued, the Group Chief Financial Officer was Mr. Anuj Singh at the time, wrote to both McKinsey and regiments and requested them to, quote, mobilize a McKinsey-led consortium, he says, to have initial discussions with our teams. But we know now from what we have seen, it wasn't just discussions. They were mobilized to do actual work. And I think that, for me, is a fundamental breach of process. As a result of this, Chair, we actually felt the need to issue a further directive to business. And I deal with that in paragraph 136. The directive itself, I think, is attached as PV 46, which...
Chair, it's on page 1353.
And I don't propose to read the entire directive, Chair. Safe to say that this directive explained to business that a confined tender process is still a tender process, and that no one should jump the gun, that everyone should wait until the tender process is completed, be it a confined tender process or an open tender process. There should be no engagements with a bidder until that process has been completed, and only after the relevant delegated body has made the award, only then can one engage and issue letters of intent, and contracts can be concluded, etc. And that is, in essence, the contents of the directive that was issued.
Was that directive prompted by knowledge of the response to Miss Cindy Felix? What was the name? Felix.
Yes.
To Miss Felix's email.
Yes, it was, Chair.
It was prompted by
yes,
that.
Yes, it was.
Yeah.
She raised not only Cindy, but other people in the supply chain community came to governance and said, you must address this issue because we are being asked to make payments while tender processes are still underway. And that is when we issued this to the entire organization.
And do you know whether Mr. Anuj Singh would have seen the directive quite soon after it was circulated or issued, or is that something you don't know?
Chair, it is addressed firstly to all EXCO and extended EXCO members, of which Mr. Anuj Singh was a member.
Yes.
So he would have.
So it was to be expected that he would see it.
He would have seen it.
Yeah. Okay. But after there was no change of attitude on his part after the issuing of this directive in relation to payments to this entity.
I'm not aware that there has been any change.
All right.
You conclude on that topic, Mr. Volmink, on page 137?
In paragraph
137, yes.
I simply say, Chair, that it was most irregular to engage McKinsey to commence work before the tender process, and I say that it creates the impression that the confinements to McKinsey amounted to little more than an ex post facto exercise to justify the award of business that had already occurred. Why go through the pretense of a confined tender process when in fact the teams are already on the ground doing the work? And it just creates the impression in my mind that this was ex post facto justification for what had already happened.
And from paragraph 138, you are addressing a new topic. Take us through it.
This is now still on the McKinsey contracts. I'm raising a further concern that I have with the contracts, Chair. And it relates to what we refer to as parceling of transactions.
What does that mean?
Well, in essence, what it means is that you can't break up a transaction into smaller value components to bring it to a lower level of delegation, when in fact, if you take the cumulative value, it should go to a higher level of delegation. It is even dealt with, I think, in our Code of Ethics, where it is stated that it is considered an ethical breach to unbundle a transaction into smaller components in order to avoid higher levels of authority and scrutiny. Now, I raise that in the context of the McKinsey contracts because I say that over a period of 4 days, and that is from the 31st of March 2014 to the 3rd of April 2014, when I reviewed these confinements, I noticed that the former GCE, Mr. Brian Molefe, approved 4 confinements with a combined value of 619 million. Now, Mr. Molefe had delegation to approve confinements, but only up to 250 million. Each one of these 4 falls under 250. So the first one is 130 million. The second one was 239. The third one was 150 million. And the fourth confinement was 100 million. So viewed on their own, they would have fell within his delegated authority. But viewed cumulatively, it should have been referred to a higher level, which is the Board Acquisition and Disposal Committee.
Was it the same transaction?
Chair?
Was it the same transaction? These 4 confinements, did they relate to the same job?
They relate to the award of different aspects of what is broadly the McKinsey confinement. So the coal contract. The coal contract to McKinsey was to appoint McKinsey to help us to improve our efficiencies on the coal. But the iron ore contract, which is the second one, was also geared at enhancing efficiencies, increasing revenue. The third one, which was the manganese contract, had the same essential characteristics. It was about how we can get McKinsey to help us to improve on our productivity and so on, and the NMPP contract. So they in essence relate to the same scope of work.
And they were given over a few days.
A 4-day period.
A 4-day period.
Yes.
So it's over a very short period and relates to effectively the same project.
Essentially, exactly.
Same project.
And to the same entity.
And to the same entity.
To the same entity.
And it seemed to me, Chair, at face value, that this amounted to an unbundling of these contracts to fall within the delegated authority of the GCE.
Well, we'll see in the end whether the finding will be that is what happened, but on the face of it, it does seem that these factors that you have mentioned could support what you're saying. I mean, the manganese one and the NMPP one were done on the same day.
Yeah.
Is that right?
That's correct.
3 April 2014. Why were they done separately? And then the iron ore one had been done 2 days earlier.
2 days earlier.
And the coal one had been done 1 day earlier than the iron ore one.
That is my concern.
So those factors may well support what your proposition may be.
Yes, Chair. And I conclude that point over the page where I just say that the rules around parceling in Transnet states the following, and I'm on page 63 of my statement, paragraph 141. The rules around parceling says that when the full scope of work is known at a point in time, requirements may not be deliberately split into parts or items of lesser value in order to keep the transaction within a particular delegation of authority level or to keep it below a particular threshold or a person with higher levels of delegation. This is considered parceling and will be regarded in a serious light as it amounts to non-compliance with procurement procedures. So I think the rules around that were clearly stated in the company at the time.
Yes. And yesterday you did educate us about what you termed the confidential confinements, and you had an exchange with the chair. Whether does that conform with the principles of that are enshrined in Section 217 of the Constitution, and whether can one justify that within the principles of open, competitive, transparent tender system?
Yes.
Can you tell us then what did this also entail in relation to McKinsey?
In relation to McKinsey, Chair, I indicated yesterday that a number of these confinements were classified as confidential. And I'll come back to that aspect in a moment. But first let me say this, that because confinements is a process that has great potential for abuse, where grounds are relied upon that should never justify confinement, various safeguards and levels of review were built into the process. And I mentioned that it has to start with the operating division. The end user department has to motivate for the confinement. It then has to go to the operating division CPO, the acquisition council, and the chief executive of that operating division. And then it comes to group, where it again has to undergo various levels of review from the group chief supply chain officer. And there was even a practice, although not uniformly observed, that governance had to review these as well. And I said yesterday that when a confinement was classified as confidential, none of these safeguards applied. So it sailed past all of these reviewing bodies and would have gone straight to the GCE.
Were all confidential confinements dealt with by one functionary, say the GCEO or the BATC, or were they dealt with by different bodies?
It would depend on the value.
Oh, okay. So that principle still applies?
That principle still applied, but it wouldn't go through any of the lower reviewing bodies.
A confidential confinement in effect meant that only one functionary, person or body would decide it, and there would be no multiple stages of involvement by different people.
That is precisely the case. So it would come from the author of the document.
Yes.
And be received by the approving authority with no intervening levels of scrutiny.
Yeah, okay.
Chair, I then state that on paragraph 149, I make the point that all of these levels of review are bypassed. And then in paragraph 150,
on page 65.
on page 65,
Yes.
I say that, secondly, the confinement memos contain very little, if anything, that explains why these submissions were classified as confidential. I mean,
You told me yesterday that the original source of this concept of confidential confinement came from a delegated authority from the board.
It was in the DOA framework.
Yes, that's where it came.
Yeah.
It came from originally, and you had to put it into a policy and so on. I don't remember whether I asked this question yesterday, but was it provided in that original delegated authority, or was there a provision that said under what circumstances a contract or job could be classified as, or could qualify as confidential? A confinement could be regarded as confidential. You told us yesterday and today the grounds in terms of policy, the grounds for confinement. You may confine a tender if one of the following grounds exists.
Yeah.
Was there a similar thing that was put up by the board when they came up for the first time with this concept of confidential confinement?
Chair, there were no guidelines contained in the DOA framework. I think there was simply a line that said when it is confidential,
Yes.
it can be considered by the final approval authority without directing it to the lower levels of authority. So there was, in essence, to answer your question, there were no
guidelines or grounds that were given.
No.
And who was given the authority to declare or decide that a particular confinement would be a confidential one?
The originator of the document
Yes.
would, for various reasons, state why he thinks it is confidential. It would be taken to the final approval authority, who would then review it, and if the approval authority agreed that it was confidential, it would be signed off.
It's quite clear from what you explained that it meant it was not to be dealt with by different bodies and committees and functionaries who otherwise would deal with it if it was not a confidential confinement. So in effect, would it be correct that it was therefore to be taken as confidential between the originator, the author, and then the approving body?
Exactly. That's how it would be understood.
It's quite a strange thing in a state-owned entity. Somebody says there are certain contracts which will be regarded as confidential, but we are not saying which ones. What are the criteria for confidentiality? And if so-and-so classifies it as confidential, it can come to us, and then it doesn't have to go through other people, and we'll then decide if we approve or not.
Yeah.
And that could entail a lot of taxpayers' money.
Well, that is exactly the danger here, Chair, that as we have seen in some of these instances that I'm talking about, this concern is not an abstract academic concern. It is rooted in the real experiences of the organization. Thankfully, the concept of confidential confinements has been removed by the current board. But it created huge risk for the organization at the time.
Did you ever get to know who exactly came up with this concept, or is that something that you really don't know? Apart from
I
the fact
honestly
that it came from the
can't
board.
say this individual or that individual
came from the board.
But we know that it originated from the
board,
authority framework.
But other than the confinement is what was considered to be confidential. But once a tender had been awarded, the tender itself was not confidential, is that right?
Yes, and I think that in itself is an oddity because it's confidential up until the confinement is approved.
Yes.
But then you must still issue the RFP to that bidder. It must still be received.
And at that stage, it's not
that
confidential.
part is not confidential, which is a further.
It's very strange.
It is very strange. It is very strange. Yeah.
So I wonder whether it was designed to avoid a situation where lower management and other bodies would say, no, this is not confidential, and it would be difficult for the approving authority to keep on overruling them because they may have wanted to treat those as confidential, but management saw nothing
confidential
suggesting.
About it.
Yeah.
Well, there is a provision that directs the lower level bodies as to what they must consider when approving a confinement. And it does say there must be a robust review of the grounds of confinement and the motivation for the confinement before it is taken to the final approval body. The intention, Chair, is that poorly justified or unjustified motivations either for confinement or whatever the case may be, whatever the ground of confinement may be, that if it is poorly motivated, it would be dealt with at that lower level of review so that we don't have to burden the final approval body with a poorly motivated submission. That was the underlying rationale. But if you take that reviewing bodies out of the equation, well, then it just goes straight there.
So it was a way of ensuring that certain confinement requests were not subjected to the normal scrutiny that the policies and procedures of the company required requests for confinements to be subjected to.
Yes, Chair.
That's what it was about.
That it seemed to me that was the underlying motivation.
And it wasn't about keeping secret the amounts relating to the tender, because once the confinement had been approved, there was nothing secret about the tender. The tender would be dealt with as a confined tender, but nothing confidential at that stage.
Following the
normal procedures.
Yes, that is correct.
So it seems that the idea was to ensure that such certain requests for confinement of certain tenders were taken out of the normal scrutiny of mechanisms and bodies within the company.
Correct.
Okay,
correct.
Thank you.
And Chair,
Mr. Mqwena.
It's a strange concept, Chair. Very complicated and complex.
Yes.
Firstly, a confinement in its own means that it's not open. It's not an open competitive tender. Secondly, it must be confidential.
Yeah, confidential.
So it's almost a deviation within a deviation. Confinement is a deviation, and I still have a confidential confinement. And the point that I was making is that apart from this anomaly of the principle, if one looks at the substance of the motivations, there is nothing that strikes me as even remotely confidential about what is contained in these memoranda. For instance, it says that there are declining revenues and declining volumes and EBITDA is at risk, and that McKinsey is ideally placed to help us to implement various projects. But why that could not have followed a normal confinement process? I mean, that, I think on any reasonable interpretation and reading of these confinement memos, it certainly doesn't appear that there was anything, not even an iota of information is contained that would convince a reasonable reader that there was grounds for confidentiality.
They could have simply said certain contracts, certain tenders that require confinement will not go through the normal route before reaching the approving authority. They will go from the originator straight to the approving authority. In effect, they could have said that, isn't it? Because there was nothing, if there was nothing confidential about these things, then all they wanted to achieve is simply that from the originator it should come straight to the approving authority. It shouldn't be subjected to scrutiny
yes,
by other people.
Chair, they could have said that, but the difficulty would have been that the same risk still exists where it goes from the originator to the final approver, whether you call it confidential or not, without that critical middle layer of review.
No, I accept that. We're on the same page. I'm simply saying, if one accepts that there was no basis for classifying them as confidential,
Yeah.
and that the whole point was that these requests for confinement should not be subjected to normal scrutiny by various bodies because they wanted to only certain people or certain bodies to approve them. Then all they needed to do is to say certain requests for confinement will come straight to us or to the GCEO or to the BADC. Then we would have had the same thing, namely there is no scrutiny, and they decide themselves.
Yes.
Yeah.
You conclude, Mr. Volmink, on this concern that you are raising, how McKinsey was treated throughout. You do so in paragraph 151 and 152.
Yes, Chair, I then just conclude that portion by saying that the added difficulty with using confidentiality is that it was sometimes quoted as a ground for confinement itself, whereas our rules on confinement only recognize 4 grounds: urgency, sole supplier, standardization, and what I referred to earlier as the school fees clause, where there's highly specialized things, and those are the 4 grounds of confinement. Confidentiality can be cited as a reason not to take it through the reviewing process, but we see that sometimes confidentiality is even quoted as a further ground for confinement, which I think was incorrect. Chair,
I'm sorry. You said that you had to incorporate this new procedure or requirement of confidentiality into the policy.
Yes.
After the board had put it into a delegated authority delegation. When you put it into your policy documents, what did you put as the grounds on which it could be initiated? In other words, what do you do? Did you put in some grounds, or did you just do what the board had done?
Chair, we had some debate about that, and if memory serves me correctly, the debate was resolved that on the basis that the grounds, as stated in the delegation of authority, would be incorporated into the policy. There was some concern, if memory serves me correctly, about over-regulating or over-prescribing what may be considered as confidential grounds or not confidential grounds. So it was left somewhat open even in the policy.
But you said in the delegated authority there were no grounds.
Yes. So the only ground is that if it is confidential.
Yeah, no, there can't be a ground.
So the ground for bypassing all of these delegated bodies would be if it is classified as a confidential confinement.
Yeah, so you just took what was in the delegated
I think in essence
authority.
it was incorporated as such.
And paragraph 152?
I think it is, I really just make the same point in one.
You are dealing with a further concern, which is the gap analysis. Can you explain it to the chair and take us through what you sought to convey in relation to that concern?
Chair, I point out in paragraph 153 and following under the heading gap analysis, I say that a National Treasury issued an instruction which would have been applicable to some of these McKinsey contracts, and the instruction I have annexed as Annexure PV 48, which you will find on page 1389. And what this instruction says, Chair, is that a consultant may only be appointed after a proper business case has been done and what's referred to as a gap analysis has been done to confirm that Transnet does not have the requisite skills or the resources in place to perform this work. In other words, it must be confirmed that there is no one among the 50,000 employees who work for Transnet that there is expertise of this nature. And there needs to be a proper motivation for that. There is a passing reference to that in some of the McKinsey confinements, but no proper gap analysis was done to show, and that is a mandatory requirement. It is not a nice to have. It says that the organ of state must conduct such a gap analysis before we can proceed to appoint a consultant, and I couldn't find evidence of such gap analysis.
Yes. And you conclude your statement with the last concern, that is the remuneration model.
That's correct, Chair. The last aspect which I deal with in my statement relates to the remuneration model that McKinsey sought to implement. And the McKinsey contracts made provision for two kinds of fees, Chair. The first is a so-called fixed fee component. So they would say to do preparatory work or to do whatever, there's a fixed fee, is that. And then they would have what is referred to as a contingent fee component. This was usually related to McKinsey sharing a percentage of any increase in revenue which would come about as a result of their efforts. So if I take, let's say, the coal or the manganese contract, if it could be established that as a result of their interventions, that revenue had increased by a certain amount, there would be a predetermined percentage that would be allocated to them over and above the fixed fee that they had signed up for.
So it was like a performance bonus. If they'd done such a good job that there was an increase in revenue, then they would get extra payment.
Yeah. I suppose one could regard it as a performance bonus of sorts.
Okay.
And they were paid those contingency fees.
Yes. Now, on the face of it, Chair, I was concerned that this contingent fee arrangement was not aligned to National Treasury's instruction on cost containment, which in fact there's an instruction that directs that fees for consultants will be subject to certain prescripts. You can't, consultant can't charge you whatever. And I think I may even have attached a copy of that instruction.
It's page 1398, Chair. Would that be the one, Mr. Volmink?
1398, if you just bear with me, I think it's a little bit earlier. Chair, if you turn to page 1389, you will find a copy of the cost containment instruction.
Yes.
And if you turn the page to page 1390, and if you look at paragraph 4.2, it states the following: consultants may only be remunerated at the rates, and then it lists three categories. A, determined in the guideline for fees issued by SAICA, which is the South African Institute of Chartered Accountants. B, set out in the Guide on Hourly Fee Rates for Consultants by the Department of Public Services and Administration, the so-called DPSA rates, or prescribed by a body or the body regulating the profession of the consultant. So these are regulated rates. And a concern which we had at the time is that the contingent fee model did not align well with what seemed to be regulated rates. Chair, the difficulty then, well, let me say that we then engaged with National Treasury on whether the use of contingency fees could be a basis for remunerating consultants. And the Accountant General responded in a letter to Transnet dated the 25th of June 2014. And perhaps I should turn to a Chair. It is Annexure PV 49, which is the last annexure in my bundle, and
Page 1398.
1398.
Yes.
And he responds to various questions that we had posed to him. And under in paragraph 7, under the heading Use of Consultants, the Accountant General quotes that paragraph 4.2 of the instruction which I have just read, which says what the prescriptions are for remuneration. And then, Chair, he said the following: the above-mentioned documents merely provide the tariffs that PFMA-compliant institutions may pay consultants, and these tariffs are not related to additional revenue or earnings, if any, that entities may realize or benefit from their appointment. And it seemed to open the door to the possibility of a contingency fee arrangement. And I think on the basis of this letter, Transnet proceeded to implement the contingency fee arrangement.
Yes. Now, finally, Mr. Volmink, you have dealt with a number of transactions: the Neotel network services, confinement of the CCTV, the award of the IT data service contract to T-Systems, the 100 locomotives transaction to China South Rail, and the McKinsey consulting, the confinements that you have taken us so eloquently through. What do you make about these contracts? What do you make about the conduct giving rise to the issues that you have raised before the chairperson? Could you ascribe this as sheer incompetence or lack of understanding of the applicable prescripts?
Chair, I've sought to give a candid view on the compliance with prescripts that was followed. And if the rule that was not followed, if it was an obscure, highly complicated, difficult to understand provision, then I would be more inclined to think that there could be just innocent bungling. But Chair, if we look at the rules around how confinements are supposed to be done, the principle that you can't pay someone before you award a tender to them, all the other breaches that I've dealt with over the last 2 days, Chair, it is not deeply complex principles that were not followed. And it suggests, in my view, an element of either gross negligence or willfulness in not following the transactions.
Yes. Chair, that concludes the questions for Mr. Volmink.
No, thank you. Thank you very much, Mr. Volmink, for coming forward to clarify the experiences that you have found at Transnet with regard to these particular transactions and your understanding of the procurement prescripts applicable to Transnet during the times of these transactions. If a need arises, you will be asked to come back. Thank you very much. You are released.
Thank you, Chair.
Thank you.
Thank you, Chair. Mr. Pretorius will address you.
Chair, the next witness for Transnet is Mr. Mohammadi.
Yes.
He won't give evidence today because we are adjourning early today.
Yeah.
And I understand that Monday as well as Tuesday, the Chair and others are otherwise engaged, and that unless you decide otherwise, Chair, we will begin on Wednesday once more at 10 a.m. with Mr. Mohammadi's evidence for Transnet.
Yes, we will not sit on Monday and Tuesday. We will resume on Wednesday. I was thinking that we should try next week to start earlier than normal to try and, if we can, recoup some of the time that we will have lost. We might not be able to recoup all of it. Are you able to indicate whether there will be any difficulties from the legal team if we start early on Wednesday?
Well, there are two issues, the availability of the witness and the evidence leader, that can always be arranged.
Yes.
The other, however, is that the legal team are involved in other tasks and it reduces that time.
Yes.
But if the program permits, then certainly our preference would be for the normal hours. But if your concern is to make up time, then we shall just have to start at 9.
Do we have an idea how long the next witness is likely to be on next week?
2 days, and I'm informed by Mr. McQuina that if we start at 10 on Wednesday and Thursday, we will finish Mr. Mohammadi in 2 days.
In 2 days. Okay, maybe let's start at 10 o'clock on Wednesday. If we need to change, we'll announce. So on Wednesday, we'll start at 10.
Thank you, Chair.
Yes. We'll then adjourn for today. We adjourn.